We will not see him. We'll get started in a few minutes as soon as I have confirmation of the two that are trying to join are actually with us.
Hi, I'm going to unmute some of our call-in users so I can see if I can identify which one is Daryl. Daryl, can you speak?
And Elizabeth, I don't know if you can tell that Nick Darnell also had to join by phone.
Yeah, I'm going to need our board members on the phone to just keep speaking for a moment so I can try to identify which call-in user they are. It doesn't show me cell phone numbers.
So keep speaking like an extended sentence.
Yes, that would be really helpful. Nick and Daryl, can you hear me?
Elizabeth, can you hear me? This is Nick.
Yes.
Okay, perfect.
Daryl, if you hear us, go on and keep speaking.
Hello? Hello? This is
Daryl?
I hear Carl.
This is Daryl. This is Daryl. Can you hear me?
All right, we can hear you.
Good.
I think we're about ready, Madam Chair.
Thank you. It is 2:05 p.m. and I call this meeting to order. Good afternoon to everyone who's joining us, and especially for the special call meeting of the State Board of Education. Amy Owen on our staff will call the roll to establish a quorum.
Thank you, Madam Chair. Mr. Cobbins,
Here.
Mr. Darnell,
Here.
Mr. Eby,
Here.
Mr. Edwards,
Here.
Mr. Ferguson,
Here.
Mr. Jensen. I see Larry.
Yep.
Great. Ms. Kim.
Here.
Mr. Morrow. Dr. House. And Ms. Hartgrove.
Here.
Madam Chair, you have 8 members present.
Can you hear me now?
Yes.
Okay. All right.
Thank you. We have a quorum present and we are duly convened. We'll move into item 1, statement of necessity, and Ms. Angie Sanders will read that for us.
Madam Chair, pursuant to Tennessee Code Annotated Section 844-108, the State Board submits this determination of necessity for its special call board meeting held via WebEx at 2 p.m. on July 1st, 2021. This special call meeting was called to consider a number of time-sensitive issues prior to the beginning of the 2021-22 school year, including emergency rules necessary for implementation of educator licensure legislation passed during the 2021 legislative session, emergency rules related to virtual schools and virtual education programs, as well as options for districts to serve students who are quarantined due to COVID-19 in the 2021-22 school year. Due to the time-sensitive nature of many of the items on the board's agenda and due to the fact that board members reside across the state, it was determined that a physical quorum of our members could not be assembled in Nashville for purposes of this special call board meeting. And as such, the meeting should be conducted electronically. Notice of this meeting was posted on the State Board's website along with the agenda and instructions for accessing the WebEx. With that, Madam Chair, I will turn it back over to you.
Thank you, Angie. I'll take a moment to turn to Dr. Sarah Morrison. She's being recognized for a few remarks. Dr. Morrison?
Yes, thank you, Madam Chair. Good to see you and our other members and partners at the department, others of you joining from the public. Thank you all for joining us ahead of a long holiday weekend. And some of us have had some technology issues today, so appreciate everyone's perseverance. And as Angie said, also our board members in particular, I appreciate you making time on this July 1st date ahead of the holiday. There are only 3 items on our agenda, but they're all extremely important and time sensitive ahead of the coming school year. So it's important that we take action today, and I appreciate everyone taking time to come together to discuss the 3 emergency rules that we have before us. Look forward to seeing all of you in person in Nashville later this month for our quarterly July meeting. Turn it back over to you, Madam Chair.
Thank you. Thank you, Dr. Morrison. I do want to remind everyone, as always, that all of our items do require a roll call vote, and members making the motion and the second, please state your name for the record. We'll now move into the consent agenda, and I need a motion to approve. This includes item A and B. Is there a motion to approve?
Bob Eby so moves.
Mr. Eby provides the motion. Is there a second?
Gordon Ferguson, second.
Mr. Ferguson provides a second. Ms. Owen, would you please call the roll?
Mr. Cobbins. Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Edwards.
Aye.
Mr. Ferguson.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen.
Aye.
Ms. Kim.
Aye.
Mr. Morrow. Madam Chair Hartgrove.
Aye.
Madam Chair, you have 9 ayes.
Thank you. The ayes have it and the consent agenda is approved. Now we'll move into item 3, final reading items. Reminder, each presenter, please state your name for the record. Thank you. We'll move in and move into the first item, which is item 3A, educator licensure rule. Mr. Michael Durline.
Thank you, Madam Chair and board members. My name is Michael Durline, Senior Director of Educator Licensure and Preparation at the department. The educator licensure rule, specifically sections -.03 through -.05 and sections -.10 and -.11 govern the issuance, renewal, advancement, and reactivation of educator licenses, including academic and occupational teacher licenses, school services personnel licenses, and instructional leader licenses. In addition, there are some changes to -.11, which governs endorsements issued on educator licenses. So all of the changes before you are in response to public chapter number 125 and 493 of the 2021 legislative session. And they include things such as revisions to out-of-state licensure pathways for academic and occupational teachers, school services personnel, and instructional leaders. In some cases, this means adding out-of-state pathways where there were not previously pathways. Also, it includes removing assessment requirements for individuals who hold a professional license in a state with which Tennessee has reciprocity, and the addition of flexibility to the pathway by which an educator may waive assessment requirements for advancement due to a lack of overall level of effectiveness data. Lastly, to address public chapter 493, there is language permitting academic and occupational teachers, school services personnel, and instructional leaders who have allowed their license to lapse in Tennessee the ability to use a valid professional license issued by another state to reactivate their Tennessee license. In addition to those primary revisions, there have also been some edits made for clarity and consistency, including removing the requirement that content assessments be no more than 5 years old. This will address challenges faced by educators who are seeking to transfer to Tennessee with a practitioner license or individuals who do not hold a license in another state. By allowing the issuance of a practitioner license in Tennessee if an educator has qualifying scores on all currently required assessments. Happy to take any questions if you have them.
Are there any questions for Michael?
Madam Chair, this is Bob Eby.
Yes, Mr. Eby.
Yeah, I've got several questions here. First, in Rule 3B2, it talks about being enrolled in state board approved educator prep program, embedded clinical practice, then they would be issued a practitioner's license. What happens if they drop out of that clinical practice? Do they lose their license?
They do not. Good question. And this is one that I know we spoke about many, many years ago when we were first drafting the policy revisions. Essentially, for the lawyers on this call as well, they may want to chime in here, but a license is a property right. And we do have a system set up in TNCompass where if someone is not on track in their program, their EPP can mark them as off track. That is visible by a district, but it does allow them to transfer to another program if there were issues in the program they were initially enrolled in. But no, the license is not taken away. If they do not complete the program within those first 3 years on the practitioner license, it cannot be renewed, and they would have to go back to a program and complete that program in a more traditional sense before they could be, reactivated. But in those first 3 years, no, that's not taken away during that period.
So is there a way that they could go off track within an EPP program where they're out doing their embedded clinical practice and they keep their license and then they turn around and go to another district or something like that and start teaching under that practitioner's license and nobody would know about it? Is that possible?
Not exactly. The district, the employing district would be able to see that information as to whether that person is off track in their program.
Okay.
There is also a report in our system they can pull to be able to see any educator in their system that is off track.
Okay, thanks. Next question. Do you mind if I go ahead, Lillian, or did you want to?
No, please go ahead with all your questions.
Okay, in section 3, it talks about, and throughout this thing, that people, if they have an out-of-state license, hold an out-of-state license, then professional license from a state other than Tennessee. And then I know I saw reciprocity in there from before. Are there certain states that have reciprocity and certain states that don't have reciprocity, or how do we don't
Yeah.
define in this rule states with reciprocity, we just say states. So the way I read it is if they have a license in any of the 50 states, then they automatically have a license here, or is that something we need to look at?
I think what I'm hearing is a potential revision to the language to be a little more specific around reciprocity and what that means. We follow the NASDAQ interstate agreement, and so any entity that is partner to that agreement would be considered a state or an entity that has reciprocity with Tennessee. And I think there are a handful that are not part of that interstate agreement, but it is the vast majority. So if, I'd defer to folks regarding a potential revision if we need to clarify that as part of this emergency rule.
I think that, again, to be clear, because right now what you're saying is there's at least a handful of states a person could have a license with that we don't have reciprocity or that are not a part of this NASDAQ interstate agreement. So, Madam Chair, I would move that we amend that language to include hold a valid professional license level license from a state other than Tennessee that's a member of the NASDAQ interstate agreement. Michael, does that address that?
It does. I would suggest, though, that if that amendment is going to be made, it will need to be made anywhere in the rule where an out-of-state license is mentioned.
Right. Yeah. Every place that we talk about out-of-state license, we need to add that in there.
Yeah.
So I will make that as a motion. We can hold everything until the end, or somebody can second that right now, and we can address that now. Madam Chairman, your call.
Let's take it now. You're making a motion to amend the language regarding reciprocity, and would you restate the language? So it's
Yeah, so
crystal clear.
everywhere in this rule where it says if they hold a valid professional license from a state other than Tennessee, then we should amend that to say hold a valid level license from a state other than Tennessee that is a partner in the NASD TEC interstate agreement.
We have a motion to amend with the language that Mr. Eby just read. Is there a second?
Mike Edwards, a second.
Mr. Edwards provides a second. Any discussion?
Yeah, I think it's just a protection for us in those handful of states that don't have that agreement.
Thank you. I think that does clarify clearly what we needed to have added. No discussion, hearing no discussion. We need to call the roll to approve this amendment.
Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Edwards.
Aye.
Mr. Ferguson.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen.
Aye.
Ms. Kim.
Aye.
Ms. Hartgrove.
Aye.
Madam Chair, you have 9 ayes.
The ayes have it, and the amendment is approved. Are there any other questions regarding this particular area, this particular item?
Yes, Madam Chair, I still have some comments. In item number 11 and throughout where it talks about that we struck the statement to submit qualifying scores on all state board required assessments, and we struck that are not more than 5 years old as defined in the professional assessments. And so if I read, the way I read this is that if a person has a license and they decide that, they're not going to teach, or they move out of state or something, and before they had to have this score within 5 years. And I understand, obviously, there's some concerns there. But if a person could wait 20 years or 25 years and then come back in and reactivate their license with, if I read this correctly, with no additional assessments or anything else. And so, as standards change every 6 years, what's our protection against that? That we have a quality teacher. Just a question.
Yeah, good. Yeah, that's a good question. As standards change, so do the assessments. So we took a look at all of the assessments that are currently accepted in Tennessee, and as an example, asked ETS to tell us when were they last updated. And virtually all of them, in fact, I think all of them were updated within the last 10 years. So that situation that you described couldn't really happen in this case, but most of them were revised in much more recent years. So as those national standards change, testing organizations that we work with go back to those assessments and make sure that they're well aligned to the current standards.
But the individual doesn't have to come in and retake the assessment to regain their license, do they?
They would if the assessment that they took was an old assessment that the board doesn't currently accept.
Oh, okay.
So
Okay.
yeah, that's kind of the intent there, is that 5-year marker was somewhat arbitrary. We had some folks coming in from out of state. Let's say Kentucky adopted the same assessment that Tennessee did, but they did it a year earlier, and maybe we're looking at an assessment that's 6 years old, but it's the exact same assessment, exact same cut score. We ran into some challenges there. Now, of course, now the new law would allow someone with an out-of-state professional license to reactivate without scores on the assessment.
That still doesn't, so that addresses the change in assessments, but it doesn't address if a person came back 20 years from now and decided they wanted to reactivate their license, that they are just as effective, or they can effectively teach. Is there any way to protect us on that?
I would probably have to defer to general counsel, given the language in the public chapter that, to the best of my knowledge, reads as though if they hold a professional license in another state, we have to accept that for reactivation.
I know we can't do it for this emergency rule, but I guess before we pass the permanent rule in July or whenever we're going to address that, I would like to have a better understanding of, again, how we assure that the quality and effectiveness if a person's been out for so long. That's what ostensibly, I guess, the 5-year requirement was, and basically we've taken that totally off the table now. So I don't know if other board members have that concern or not, but it just seems to me it's something that we ought to look at.
Mr. Vice Chairman and Madam Chairman, just to give a little color and context to that, as far as as the legislative intent was, it was basically to put those teachers on kind of an equal footing with others who had started their career in other states. So, but I think this is this kind of conversation and this sort of digging in is exactly what the legislature would expect of the board.
Thank you,
Madam-
Mr. Jacobs. Thank you. Yes.
Madam Chair, this is Angie Sanders, General Counsel. Since Michael mentioned it, he's correct. The law requires, the way it's currently written, that if they have an active professional license in another state, that they be allowed to reactivate their license in Tennessee. That does mean, I think, in the majority of states, to have an active, valid professional level license, that they have to have been keeping that license up and going through whatever they have to do in the other state. So likely they have either been teaching or keeping up with their professional development to maintain that license. And then in terms of the assessment being 5 years old coming out, I think I agree with Michael's point that it still has to be the currently required assessment. So unless Tennessee's assessment hasn't changed in 20 years, it's unlikely that someone who hasn't been teaching for the past 20 years can come back into Tennessee and reactivate their license using their old scores. That would be probably a very unlikely situation, given the fact that, as Michael pointed out, standards change generally around every 6 years, which usually means that the assessment would change.
So is that, I'm sorry, I forget what I read in there. Is that explicitly stated in that rule that if the assessment has changed, then they have to redo it, retake the assessment?
Yes, it says that they have to submit qualifying scores on the required assessments that are defined in the professional assessments policy. So if their scores are on a prior exam, it would not count. It has to be the currently required. And this was a question that we went back and forth with the department leading up to this was, are we talking about the assessment that's required when they submit their application? And that is how it is interpreted.
Okay, so whoever, we as the one providing the license reactivation would tag that when the person came forward to reactivate their license, we would, somebody would check that out and make sure that wasn't the case.
That's correct.
Okay, all right, thank you. Couple more
Ms.
questions.
Sanders, and
Okay.
Mr. Eby, before you proceed, Ms. Sanders, would you also clarify for the record, because you did a little bit of research while we were on this call, it doesn't change the amendment, the first amendment that Mr. Eby made, but with regard to, you have indicated all 50 states are actually members, is that correct?
Yes, I just did a little bit of quick looking on the NASDAQ website, and the current NASDAQ agreement, all 50 states are signed on. So currently, it would cover every state, but I don't think it's a bad addition. Just to be clear, if for some reason a state is pulled out of that agreement, regardless, we still have the law as a backup. The law is clear that they have to be in the reciprocal agreement with Tennessee, but in terms of public notice and clarity, I don't think it hurts to include that.
Okay. All right, the last comment I had is we talk about the new endorsement pathways, and I certainly support that. Obviously, from the last meeting, I showed that. But my question is there a way to maintain some kind of database to assure that those pathways are just as effective in educating the teachers, or assuring that the teachers who have endorsements in those areas as say from the EPPs or whatever? How do we know 3 years from now, 4 years from now, or a year from now, that by going through that pathway, the students are getting the same level, are getting an effective quality of teaching?
I think that's a good question. And in part, if I recall, one of our recommendations for the additional endorsement pathway was accountability that would include this. I know we had that conversation, I want to say last month. I don't remember when that was. It feels like it was yesterday. Whenever that was, the last time we met.
It was in May.
All right, thank you. It is July 1st, to be fair. Yes, I think that makes sense. There are certainly some nuances there that we would want to consider, such as, the additional endorsement pathway that we've proposed would be really only available to individuals holding a professional license. So these are folks who have been in the classroom for, at a minimum, 3 years. And so, there are some things to consider there when you're comparing individuals who just completed a program and are entering their first, second, and third year teaching versus those who may have been teaching for 20 years or more and opted to complete the additional endorsement pathway. So I think these are some really good research questions. Certainly, we look very closely at the effectiveness of ed prep providers through the State Board's teacher prep report card, as well as the EPP annual reports. But I think it's always a good idea to look at all of the pathways and their effectiveness.
Okay, as we move toward, again, the permanent rule, I'd like to continue that conversation and think about, particularly, like say, right now, for TDOEs, they're talking about for special ed and for English as a second language, but I think the law may add other endorsements. And I just want to be sure that, we're any additional endorsements that the person or the teacher is effectively teaching, how we can evaluate that. So again, the students don't get the short end of that stick.
Yep, that makes a lot of sense.
Okay. Sorry, that's all my comments, Madam Chair. I'll be quiet now.
Thank you, Mr. Eby, as always. Are there other questions or comments from other members?
I have a question.
Mr. Jensen, please proceed.
I think I know the answer to this, but I'm just curious, are we doing this on an emergency rule for this next school year? Is that the driver of this?
Yes. Madam Chair, Amy Owen, Policy Director for the board. The law that allows these changes became effective today, July 1st. And we spoke with TOS, the Organization of School Superintendents, to ask, would it make a difference in their process as a director, as folks in HR who are doing hiring, to have the rule catch up to the law and go into effect on the very day it could, as opposed to waiting until the July 23rd meeting. Okay. Sometimes 3 weeks makes a difference, sometimes it doesn't. In this case, the response was that it would make a very big difference as they finalized hiring decisions moving into the next school year.
But we would have a first reading on the 23rd, correct? And then
we will, yes, sir. So this emergency rule will go into effect very shortly, assuming you all approve it, and it lasts for 180 days. And then on the July 23rd meeting, we will have a permanent version of this rule up on first reading. We'll hold a rulemaking hearing for public feedback, and then it would be on final reading at the October meeting. So the idea is that there's as small a gap as possible, hopefully no gap, between when the emergency rule is in effect and then the permanent rule goes into effect as it expires.
Okay. So this is really addressing this next school year. That's why we're acting on this today. Okay.
Yes, sir.
Thank you.
You bet.
Other questions or comments? Hearing none, is there a motion to approve item 3A as amended?
Madam Chair, this is Bob Eby. I so move.
Mr. Eby provides the motion. Is there a second?
Gordon Ferguson, second.
Mr. Ferguson provides a second. Any further discussion? Hearing none, Ms. Owen, please call the roll.
Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Ferguson.
Aye.
Sorry, I skipped you, Mr. Edwards. Forgive me.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen.
Aye.
Ms. Kim.
Aye.
Ms. Hartgrove.
Aye.
Madam Chair, you have 9 ayes.
The ayes have it and the motion is approved. Michael, thank you so much. I appreciate your due diligence in this body of work and for answering all the questions. Very good. Next up is item 3B, School Health Emergency Rule. Ms. Christy Ballard.
Good afternoon, Madam Chair, board members. My name is Christy Ballard. I'm the General Counsel for the Tennessee Department of Education. The item you have before you, the School Health Policies Emergency Rule 0520-01-13-.01. As all of you know, Public Chapter 652 of 2020 authorized the State Board of Education to promulgate rules to address COVID-19 related school disruptions. So this emergency rule, revising the school health policies rules, does just that. It actually authorizes LEAs and public charter schools to adopt a policy for the 2021-22 school year only, allowing students who are quarantined due to a positive COVID-19 test or exposure to participate in remote instruction on a temporary basis during just the next school year. The rule specifies the instructional and attendance requirements for temporarily quarantined students and clarifies that LEAs and public charter schools can only permit students to participate in remote instruction on a temporary basis due to COVID-19 exposure and quarantine. With that brief overview, I stand ready to answer any questions.
Thank you. Are there questions for Ms. Ballard?
Madam Chair, Bob Eby.
Mr. Eby.
So as I read this thing, it talks about quarantine due to a positive COVID-19 test result or possible exposure to COVID-19. And I guess my question there, clearly positive test is easy to validate and verify. How do you verify a quote possible exposure? And I guess my question there gets into, is it possible that could be abused in some way, shape, or form with regard to the quarantine aspect?
That's a really good question. And what we learned over the past of the last school year is in most instances when students were required to be quarantined from school, the contact tracing that was done in many cases was done by the actual school district in conjunction with the local health department. And even if the school district was not involved in the contact tracing, they were in close communication with the local health department. So I think it would depend on how it works in each local district. And that's why we defer to each district to have a policy. And they certainly could have a strict policy in place requiring some type of documentation.
Right. Thank you, Christy.
Okay.
That was a good question, Bob, as always. And I know several of us attend the Director of Study Council meetings, and I know this was a topic of discussion early on in most of the meetings that I attended. And it was difficult for them with regard to the fact that there were students that were in quarantine. They would come back to school, they would get re-exposed, and they'd had to go back out into quarantine. And there was deep concern about the learning loss that was occurring for those students in those scenarios. So, I agree that I think it is in the best interest of the LEA, and I believe many of them did adopt strict measures with regard to that this first go round. So I do agree it's on the LEA. So thank you for that, Ms. Ballard. Other questions or comments? Is there a motion to approve item 3B?
So moved.
Mr. Jensen provides the motion. Is there a second?
Second,
Smack.
Paul Cobbins.
Heard two people at the same time. So I believe Mr. Edwards, you were in there too. Mr. Edwards provides the second. Any further discussion? Hearing none, Ms. Owen, would you please call the roll?
Certainly, although I will say I will be glad to return this job to Casey in July. I'm sorry for mangling the alphabetical order. Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Edwards.
Aye.
Mr. Ferguson.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen. Ms. Kim.
Aye.
Ms. Hartgrove.
Aye.
Madam Chair, you have 9 ayes.
The ayes have it and the motion is approved. It doesn't matter that it's in alphabetical order. It matters that you're here to call the roll for us. So for that, I thank you very, very much. Okay, moving on to item 3C, Virtual Education Emergency Rule. Ms. Ballard is up again.
Thank you. Again, Christy Ballard. I am General Counsel for the Tennessee Department of Education. And this item is the Virtual Education Emergency Rule 0520-01-03-.05. Title 49, Chapter 16 of the Tennessee Code Annotated authorizes LEAs to establish public virtual schools and offer public virtual education programs. And so the state board is also, pursuant to that law, authorized to promulgate rules related to virtual education. So this emergency rule actually revises the current virtual public school rule based on Public Chapter 652 of 2020 that authorizes the state board to promulgate rules to address COVID-19 related disruptions. Over the past several months, we have heard that from the department, and I think the state board staff have received inquiries about LEAs related to virtual education options for the upcoming school year. Previously, because the rule that's currently in place only addresses virtual schools, we thought it was necessary to break this rule up It's separated into two sections, one section on virtual schools, one section which is brand new on virtual education programs, because we are getting lots of questions about the difference between a virtual school and a virtual education program. So this item actually clarifies the differences between those two. What is a student's complete educational program, a public virtual school, and a public virtual education program, which may be a course or a series of courses that is a part of a student's complete education program. So the revisions further define those differences and specifies the conditions under which LEAs and charter schools can actually offer virtual education programs. The rule outlines instructional and attendance requirements for virtual education programs. It also very specifically clarifies the teacher of record and what is a teacher of record for a virtual school and a virtual education program. So there are some similarities between what is now in virtual school rules and virtual program rules in this draft, but I can answer any questions. And I do have one technical correction that we realized very late in the game. There's a minor technical correction that needs to be made to paragraph 1E. It is actually a duplicate to paragraph 1D. So we would ask that the state board staff remove it and renumber those sections accordingly, because it is literally just a duplicate. And with that brief overview, I stand ready for any questions that you might have about this emergency rule.
Do I just go directly to Bob Eby, or?
I have some questions.
Well, let's see if anybody else has any questions.
Yeah, I
first.
agree. I agree.
Are there any questions from members? And then we'll go back to Mr. Eby.
And Madam Chair, at the end, by the way, when if it's your desire, the thing to do would be to entertain a motion to authorize the staff to make that technical correction, and you can vote on that with anything else.
Okay.
Madam Chair, may I chime in with a little more background on this one?
Yes, please do.
I just wanted to share that our staff, in conjunction with a few staff at the department, actually reached out to about 6 school districts, as well as a charter network and several advocacy organizations like TSBA and TOS to talk about this area, because we knew that there were districts with virtual education programs already going on, and we wanted to learn what their most effective practices were, where they had lingering questions, as Christy noted, about things like teacher of record, and make sure that we were providing guardrails, but we're not stifling innovation in this area that is evolving so quickly. So I did want to let you know that we did a fair bit of legwork on the front end to help develop these rules. And we'll certainly be interested in feedback as we move toward the permanent rule later this month.
Very good. Thank you for that addition. Mr. Eby.
Well, first, let me say I'm really excited to see this rule come in and provide the flexibility for the programs on top of the schools. I think this is going to be very beneficial to our students. But I do have a couple of questions. One, it talks about the teacher of record monitors the physical safety and well-being of students. And I guess my question is there a training, or how is that done when the student is virtually, not present there? Is there a process that's done, or is that left up to the districts to decide how to do that, or what?
That's an excellent question. And when I was talking to educators and the state board staff about, what language to put in about teacher of record for virtual education, the point that kept being made is a teacher of record should be very similar to a teacher in the virtual environment as a teacher of record in a brick and mortar school. Children should have that same access to a qualified teacher. And so in the same way that a teacher in a brick and mortar school is charged with monitoring the safety and well-being of students, the same thing is expected of a teacher of record in a virtual education program or a virtual school. For example, and we got some actual questions during last year about things like this. For virtual education programs, teachers sometimes will break students up into virtual rooms for discussion and for activities. And we would get questions about if a student is bullying another student in that virtual environment. That teacher has the same duties under the law and the state board rules to report and to investigate and to take action against bullying in that setting as they would if it was happening in a regular classroom. In the same way that a teacher in a regular brick and mortar school classroom is charged with reporting suspected child abuse, they would have that same responsibility. If you see a child on camera with 2 black eyes, and you have other reasons to have suspicions, you would still have that same obligation. If you see something in the child's background that puts the student at risk, it could be, a handgun on a second grader's dresser behind them in camera. That's one example that I heard. I think the point we were trying to make is really the rules are the same. They may have to be applied a little bit differently in the virtual setting, but a teacher of record is a teacher of record, and we wanted to make that really clear in the rule. Does that help at all?
That helps greatly. I just hope the districts do a good job of explaining that to the teachers and making sure they understand their responsibilities. No, that's very helpful. Thank you. Another question I have, it says in number 054, a student may participate in a virtual program without enrolling in a virtual school, provided, however, that the student must be enrolled at the school where the student receives the majority of his or her instruction in each school year. Student participations in a virtual program shall be at the discretion of the LEA or public school where the student is enrolled. I thought that one of the benefits that we talked about the virtual program was to have maybe students from another LEA or another school participate in the virtual program so they could have courses maybe that weren't offered in their school that could be offered elsewhere. And the way I read this is they must be enrolled at the school where the program is. Is that a restriction we're putting on it?
I think I don't read it as limiting that in that way, and we might want to tweak it just to clarify that if it is confusing. The idea with this provision was to ensure that accountability for the student remains in their school of primary enrollment. So if I am taking all of my courses in one school, but I'm taking 2 courses through the virtual education program, maybe even in another school district, my grades and accountability would still remain with my home school or the school where I'm taking the majority of my courses. That was the intent of that provision. If we need to tweak that to make that more clear, because we certainly did not want to promulgate anything that would prohibit good things that have been going on for years with virtual programs. And we know that some school districts open up their virtual courses and programs to other school district students. So that was not the intent.
Yeah, I think maybe some way we ought to try and tweak, just make sure it's not clear and it's not contradictory to what we have in the past. I'm trying to think of how best to tweak that in the short time period that we have here.
Mr. Eby, if it would help, when we did speak to the school districts and we also spoke with the TOS board, the school districts that we spoke with, even those that had historically allowed students from outside the district to participate in their programming, indicated that they might not be doing it for this upcoming school year, just given all of the flux coming in around COVID, that they wanted to focus on their district students first, making sure that they were being served through the available programming and might in the future reopen to other districts. Now, we didn't call up 147 LEAs,
Sure.
but of the folks that we talked to, a lot of them had historically been involved in this space and were really looking to hunker down a bit and focus on their LEA students for the upcoming year.
Okay, so we could go forward with the emergency rule, and then as we look at the permanent rule, maybe look at for the following year, look at some changes. I'm fine with that. Thank you. And then the last comment I have, again, at the very last 11F, it has these things that a virtual education program policy that the districts have that should contain the following, and there's a whole list of things, A, B, C, D, E. I was wondering, how do we include, once again, the effectiveness or assure the effectiveness of the virtual programs? Students are getting them. How do we evaluate that it's an effective program and they're getting the same quality education as they do in class or whatever? Just question.
That's a really good question. I do know it's easier when it's a virtual school because the accountability lies with that school. When it's a program, it's usually a course or series of courses. And I'm not sure that we track it, Algebra 1, virtual versus Algebra 1 brick and mortar, because it is the same course. The instruction is just presented differently. I would have to defer to other members of the department to look to see if that can be readily done now, or if we would have to do something else to ensure that we could track the difference between a student taking a course virtually versus in person.
Yeah, I don't see that as being a immediate thing. I mean, I think, you got to run through the process and get some evaluation. But again, I think this is something that I would recommend that for the permanent rule or for implementation down the road, we look at, if we're on the path to continuous improvement, we want to know where we are and where we're going and comparing. And so I would like to see further conversation and movement in that direction. That's it.
I certainly think we can have additional conversation because one board member requested, and I think an opportunity for everybody to weigh in would enter into the equation. Because when I think about this, and I wholeheartedly agree, we definitely want to make sure that virtual education is at the highest level possible. And I'm getting some feedback from, I'm not sure if you all are hearing that too. I think about the responsibility also is on the LEA to ensure that any class, any program that they offer in person or otherwise is of the highest quality, and measuring the student successes and those who are enrolled in those classes, I think are very important. And I wonder about an undue burden on them to provide such detailed reporting across the entire state, and the department capturing all of that information. I do think that there's local responsibility to ensure that what they're offering is valid and high quality and students are successful. And I would believe that they're going to stop offering it if it's not the case. That's my personal opinion. And there are times that I believe that it's not our responsibility at the state level to monitor individual singular courses. That's just my opinion. So for what it's worth.
Madam Chair, this is Angie. Can I make one comment?
Ms. Sanders. Yes, Ms. Sanders, please.
So 4916-104 actually does require the Department of Education to submit an annual report on virtual education programs. But I think the point that Christy was making is that it's hard sometimes for them to drill down to the actual course level. But that's certainly something we can continue to talk about. But the requirement for a report annually is in the law. And I know that the department does compile and submit that report. So I think it would be good to maybe see if we could get a copy of that and examine how maybe that can be improved in the future. Another point that I want to make, which I think goes exactly to what you were just talking about, is I believe it's the very last paragraph of the rule, or the second to last paragraph of the rule, does talk about that the district's policy needs to include interventions for students who are struggling to maintain eligibility requirements and a process for removing students from those courses who fail to maintain eligibility requirements and placing them into a comparable in-person course. So we're trying to put some guardrails on there for districts to say if a student's struggling and they're not able to maintain their grades in a virtual course, that there would be a process for them to be moved out of that and into an in-person course.
Thank you. I understand the individual students. My concern is, again, the concept of the virtual versus the in-person as more as a whole or as a global issue to assure that, the students are getting the same level of education.
Madam Chair, this is Jack Powers at the Department of Education. If I could just offer one comment here.
Go ahead.
I think that one of the things you'll see in this report that we're going to send along to you all on virtual education programs is that we do have the ability to kind of publish some data, especially as it relates to public virtual schools, to kind of draw those big, broad comparisons there. The other thing I'd say just in terms of virtual education programs is just to keep in mind that, and as you read the rule, I think this comes through, that they're designed, I think, to be very unique and tailored to the needs of an individual student. One of the I know that one of the pieces we heard, or that I heard through state board staff, is how certain districts use these virtual programs to let students take advantage of work-based learning opportunities and internships that might occur during the regular school day. Another student may have to access a virtual education program because they're homebound. And so those are, in the statistician's world, variables that can come in and affect, what you're ultimately looking at, which is the student achievement data. And so I think that that's just something to keep in mind as we kind of try to answer that interesting question about the effectiveness of a virtual education program. It's just that they're so unique. I, for one, am very interested to start kind of seeing the many different ways that districts, use this newly kind of carved out and defined space in the rule. So.
Thank you for that additional information, Jack. Any other questions or comments?
I did have one question.
Yes, Mr. Johnson.
I had a constituent ask about charter schools, and I think I'm hearing that there was some prohibition prior to this to make it more difficult for charter schools to access virtual. Are you aware of that, and has that been addressed?
I can answer that. Actually, the virtual school law has been in place since 2011 and has always prohibited, there's a specific language in the law, virtual charter schools. So what you will see reflected in this rule is you don't see the language about charter schools in the virtual school portion of the rule, but charter schools are allowed to have virtual programs because there's no prohibition in the law for that. So there's a difference between the school and the program for charter schools.
And then again, a point of clarification. This applies to private schools as well.
This rule is for public schools, so LEAs and public charter schools.
Okay.
So it does not have applicability to private schools. And depending on the private school and their accrediting agency, some of them do have, virtual instruction.
Okay, thank you.
Other questions or comments? So let's go back and I need a motion to approve or to make an amendment based on the technical revision. And Nathan, tell me if I need Ms. Ballard to repeat the technical revision because I did not write that down specifically.
You certainly could.
recommend
And I'll tell you,
Yes.
Madam Chair, I mean,
Yes.
in the absence of any amendment, a member could simply move, this to be adopted, incorporating
Okay.
the technical amendment contemplated by the general counsel there, and you could have her restated, and then you could take care of it all with one motion.
Okay. Is there a motion to approve item 3C with the technical revision recommended by Ms. Christy Ballard, General Counsel for the Tennessee Department of Education?
This is Mike Edwards. I'll move.
Mr. Edwards provides the motion. Is there a second?
Second, Daryl Cobbins.
Mr. Cobbins provides the second. Any further discussion? Hearing none, Ms. Owen, would you please call the roll?
Mr. Cobbins.
Aye.
Mr. Darnell.
Aye.
Mr. Eby.
Aye.
Mr. Edwards.
Aye.
Mr. Ferguson.
Aye.
Mr. Hamby.
Aye.
Mr. Jensen.
Aye.
Ms. Kim.
Aye.
Ms. Hartgrove.
Aye.
Madam Chair, you have 9 ayes.
The ayes have it, and item 3C is approved as amended. Before we adjourn, we're at that point now. Before we adjourn, as always, I do like to ask if there are any members of the board or Dr. Morrison or Commissioner Schwinn, if there are any closing comments that you would like to make. Thank you all very much. I do want to close this out by my usual comments. I do want to thank Ms. Christy Ballard. Excellent presentation on the last two items that you presented. And always, Michael Durline, Mr. Durline, thank you for your support here today, as always. Ms. Amy Owen, I've already recognized you, but I do want to recognize you again. And our General Counsel, Ms. Angie Sanders, for her imparting the information that we need to know to move forward in a legal matter following the legislation that was recently passed. And Nathan James, I believe you're officially in London, England. Did you make it there? Thank you. Thank you for joining us remotely.
How do you do it?
I see you made it there safely. I look forward to seeing each of you at our next in-person quarterly meeting on July 23rd. We will be in Nashville. Without objection, we are adjourned. Thank you all.